If you're telling yourself these things, I'm here to tell you that you're wrong. And we're going to shift that belief and that mindset right here, right now. The fact is, big words don't win cases. What impresses your judge the most, what impresses juries the most, is if you know your facts cold, you're calm enough to present those facts in the courtroom, and you do it with confidence. That is what your case is about. It's not about a law degree. It's not about using huge words. It's about knowing the case and presenting the facts that matter. So I have come up against probably hundreds of people representing themselves in the courtroom over my 27 years of practicing family law. One thing I would venture to guess is that of those hundreds of people, probably about 98% are trying to impress the court with big legal words. And one thing that I had to learn out of law school was the fact that I had to learn again how to communicate. Yes, in law school, they teach you all these big words, but as I've gotten into my law practice, what's more important is to be able to communicate effectively, not just with my clients, but with the judge and with the jury when I was doing criminal law, because here in Arizona, we don't have family law cases in front of a jury. And the way you communicate is by being a human, by telling a story, by using words that everybody can understand. When you use words that others can't understand, they don't connect to you. What is it about the best storytellers in the world that connect to you, the best music that you love, that touches your heart, that really gets to you? It's the words and it's the ability to reach the listener. So when you're in that courtroom, don't worry about using big words. Worry about your evidence and worry about what you're presenting. I think it's a big misconception among people, especially people who don't have attorneys, that the judge or the jury is listening for vocabulary. The judge is listening for your story of the case. The judge is listening for the theme of your case. And the work that you do prior to your trial, going into that courtroom, is what makes all the difference. It begins day one when you start your divorce case or when you're served with a divorce lawsuit or a custody case. And it starts as you begin gathering and collecting the evidence and figuring out the frame, how you're going to frame it to tell your story to the judge. So a lot of times my clients get really freaked out because the other party is slinging mud at the wall. I want to challenge you, instead of focusing your whole strategy on rebutting stories, true or not, that the other side is throwing out, what about framing your story? Framing your case the way that you want. And oftentimes I tell my clients, listen, I'm not going to spend our whole case trying to defend against these allegations, which may not be true, that the other side is throwing out. Let's figure out what our strongest points are and present those to the judge. And that is your job. What are the issues in the case? Are they the division of property and debt or child custody? Are you seeking or defending against spousal maintenance? Those are your frames. And then you gather the evidence to support whatever your position is. And then you put forth your story in the courtroom. And what matters is not big words. What matters is your ability to put forth that story in a calm, collected, and organized way so the judge can follow it. I have been in the courtroom many times, even up against lawyers. And I'm always shocked when I see a lawyer go into a trial with no notes in front of them. Like, I type out all of my questions for each and every witness before each and every trial. And this is after 27 years of practice. But when I see attorneys who don't do that, I also see examinations that are not as effective because they're all over the place. There's no flow to them. There's no organization. They don't make sense. Give your judge guideposts that make it easy for the judge to follow. When I'm organizing an examination, I organize by issue. If I'm touching on child custody, I hit on each of those best interest factors. And each of those factors is a point in the story that we're telling in the courtroom. But if you don't want to watch other videos, or if you don't want to read the book, that's okay. What I am telling you is, think about an essay or a report that you had to do in school and how you had to outline it and how you had to organize it to make your points clearly to whoever it was you were presenting to, the classroom or your teacher. You wanted to make it easy for them to follow. And that is what is going to impress your judge, not using big legal words. You don't need to have gone to law school To do a great job in the courtroom, on top of being organized, the other thing you have to take care to do is know your evidence cold, not just your own evidence, but the evidence of the other side. Because when you don't know the evidence, surprises are going to happen in the courtroom. And I can tell you that in almost every case I have, surprises happen in the courtroom, even when I know the evidence. I can't imagine what it would be like if I didn't know the evidence, my own evidence, my client's evidence, or the other side's evidence. So you, on top of having to prepare an organized case, need to read each and every page of information that's been disclosed to you and that you have disclosed to the other side. That's going to make it easier for you to think on your feet in the courtroom as questions come up or testimony comes out, to rebut that, to cross-examine it, to talk about it in your own testimony. If you don't know the evidence, then you're not going to be able to fill the gaps for the judge. And sometimes those gaps are where the court makes decisions. So knowing evidence means having studied all of the documentation. I don't care if it's thousands of pages, and sometimes that's what I have to do in my cases. It's knowing those most important pieces, for example, doctor's records or reports. It means knowing dates. It means knowing timeframes. It means knowing what patterns the evidence is showing. So if you can, create summary charts, summary exhibits of the evidence. Sometimes in cases, I have hundreds of pages of text messages exchanged between the parties. Judges don't like to read hundreds of pages of text messages, but maybe a handful of text messages illustrate the point that I want to make. For example, that the other side is not co-parenting, that they're not responsive, that they're inflexible. I highlight those text messages, and those are the ones I pull out in the trial. So you need to do the same with your evidence. Know dates, numbers, page numbers, passages, quotations, important relevant statements made by professionals. By knowing your evidence, you're not going to be surprised as much as you would be without knowing the evidence. You're going to be able to think on your feet, respond more quickly, and respond with confidence. Remember, when you're in the courtroom, whether you have an attorney or not, the judge is deciding this case based on your credibility and the credibility of the other side and their witnesses and your witnesses. So when you show up prepared and when you show up knowing your documentation, you show up confident and competent and easily able to point out a document or a passage, that is going to boost your credibility in front of the judge, which means extra points for you. One thing you have to remember is you know your life, you know this case better than any big legal word could speak to. So have faith in that, have confidence in that, have trust in the fact that you can tell your story better than a law dictionary can. Connect with the judge by telling the story in your words. That's all you need to do. You don't need to talk like a lawyer. You don't need to sound like a lawyer. You just be you. The courtroom doesn't reward a law degree. It rewards people who know their own facts cold. If you take nothing else from this video, remember this. The courtroom doesn't reward big words. It rewards people who are prepared, who can calmly and effectively present those facts to the judge. That's a skill, not a law degree. You can do this. And until I see you next time, get out there and command the courtroom. Have a good one.